Person at the Wexford County Jail, could you please state your name for the record?
Skylar Jade Hall.
Buckle up, because this courtroom session is a full-blown pressure cooker. In one docket, we're about to watch a felony drug arraignment, a probation violation involving an alleged no-contact breach, a creditor's exam where every excuse gets stress tested, and a housing case where eviction is suddenly staring everyone in the face. And what makes this so compelling is that none of these cases are really just about paperwork. They're about whether the judge believes you, whether the facts hold up under pressure, and whether your story survives contact with hard questions. This is the kind of courtroom video where the stakes keep changing every few minutes. One defendant walks in needing bond and a chance to go home. Another is fighting not to be sent straight back to jail. Then the whole vibe flips, and now we're watching someone explain cars, loans, bank balances, future income, and missing money while the judge tries to figure out what's real and what sounds polished but flimsy. And by the end, we're in landlord-tenant court, where one misstep can turn financial trouble into a signed judgment and a possible eviction timeline. So here's the big hook. This entire session comes down to three things: risk, credibility, and receipts. Who seems trustworthy? Who has the documentation? Who sounds believable until the follow-up questions start landing? Because once the judge starts drilling down, vibes do not save you. Supporters in the courtroom do not save you. Good intentions do not save you. What matters is whether your version of events can actually survive scrutiny. And trust me, there are moments in this docket where the whole room changes because one answer either helps a case or quietly starts sinking it. Let's get into it.
Ms. Hall, did you have the opportunity to meet with somebody from the defender's office today?
Yes.
And did you read and sign an advice of rights form at the jail? Probably
Yes.
not, because of, okay. I have a complaint that alleges that on or about, I'm sorry, this is case number 26-217FY. Ms. Hall, I have a complaint that alleges that on or about December 15th, 2025 in Herring Township of Wexford County, it is alleged in count number 1 that you committed the offense of controlled substance possession of a narcotic less than 25 grams. That is a felony punishable by up to 4 years in prison and or a fine of $25,000. Do you understand those charges and the potential penalties?
Yep. Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process, and if you cannot afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I would like an attorney.
All right, court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove two things: 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to, you'd be ordered to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor.
Right here, the court is doing the formal groundwork, and this part is more important than a lot of viewers realize. At arraignment, the judge is not deciding whether she's guilty. This is about making sure she understands the charge, the possible prison exposure, her right to stay silent, her right to a lawyer, and what the next stages of the case will look like. And when the judge starts explaining the preliminary exam, that is the court saying the prosecution is going to have to show enough to keep this case alive, not prove everything, just enough probable cause to move it forward. But underneath all that legal structure, another battle is already starting. Perception, no criminal history, family support, community ties, requesting appointed counsel instead of trying to wing it alone. Those details matter because they begin shaping how the judge sees this defendant before the case even gets deeper. Early hearings are not flashy, but they are incredibly important because they set the tone. And tone in court? Tone can become momentum.
We'll get together to see if there was a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I do not show any criminal convictions, and the praxis scores her at a risk level 2. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. I'd ask the court to consider a personal recognizance bond. As was noted, she has no prior criminal history. She has strong ties to the community. I believe she's lived at the address that she gave community corrections her entire life. She does have moral support in the courtroom. her mother, her father, and her stepmother are all here. They'd very gladly go pick her up and give her a safe ride home. She knows, based on my conversations with her, the court very likely is going to require random drug testing. It's going to be her first time on bond, but if she has any questions, she can always reach out, not only to community corrections, but also the public defender's office. Make sure to give a business card to her family members, which I'm sure they'll pass along to her. If for some reason it gets lost, I know all the young people know how to Google on their phones, and we're right there. So I would ask the court to give her that opportunity at a PR bond. I believe it's appropriate. Thank you.
Thank you. Ms. Lawrence?
Given the nature of the charge, I would ask the court to impose random drug testing, including recreational marijuana. As for bond, I will leave that up to the discretion of the court. Thank you.
All right, I do believe a personal recognizance bond is appropriate in this case. So Ms. Hall, you will be released without posting any money, but on your promise to come back to court. I am ordering that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also ordering that you not consume any illegal controlled substances, including recreational marijuana. And you'll be subject to, well, no. No illegal controlled substance and subject to random testing.
Okay.
And I also want you to enroll in community corrections services.
And there it is, personal recognizance bond. Translation, she gets to walk out without posting cash, but this is absolutely not the same thing as getting off easy. The court is basically saying, I'm willing to let you go home, but I am putting you on a very short legal leash. Keep your contact information updated. Don't leave the state without permission. Don't pick up new charges. Don't use illegal controlled substances. Submit to random testing, and get yourself over to community corrections to get enrolled. That's the detail casual viewers miss. Release is not freedom in the everyday sense. It is conditional freedom, and the conditions are the whole story. One bad decision, one missed test, one failure to comply, and the court can come back harder the next time. So yes, this is a break, but it is a controlled break. The judge looked at the lack of prior convictions, the family presence, and the overall record and decided supervision could work. For now. That for now is doing a lot of heavy lifting.
Okay.
At some point, you'll be released from the jail today. You'll need to make your way over here to the community corrections office at the courthouse and get signed up for your testing. All right.
Okay.
All right. Thank you. Next arraignment.
And now the entire energy changes. This next case is on a different level because we're no longer talking about a brand new charge standing alone. We're talking about an alleged probation violation, which means the defendant was already on the court's radar, already under conditions, and already operating under a second chance framework. That matters. Courts treat probation as an opportunity. So when someone comes back accused of violating it, especially in a case involving a no contact order, the patience level gets a lot thinner, a lot faster. And the second the court connects this to the same victim from a domestic case, the risk analysis gets serious. This is no longer just, will he come back to court? Now it becomes, if I release him, am I creating a danger I could have prevented? That is a completely different question. And once the hearing becomes about safety instead of just compliance, the standards in the room shift immediately. This is where things can go from maybe manageable to absolutely not.
Person at the jail, please state your name for the record.
Preston Graves.
This is case number 24-4133 FY, the people of the state of Michigan versus Preston Lee Graves. Mr. Graves, you are here for an alleged probation violation. It is alleged that you have a non-technical violation by violating the no contact order by trying to enter the victim's residence. If you are found guilty of that violation, you could be sentenced to what you could have been sentenced to under the original plea in this case to aggravated assault, so up to 1 year in jail. You do have the right to have a contested hearing in this case in which the prosecutor would have to prove to the court that you did in fact violate your probation, or you have the ability to plead responsible to the violation. You also have the right to have an attorney represent you during this phase of the probation violation. And if you cannot afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. I guess my first question to you today is, do you want to represent yourself, hire an attorney, or have the court appoint an attorney?
I guess appoint one for now, at least.
All right, the court will make a referral to the public defender's office for the appointment of an attorney entering not guilty plea. And we will set the matter for a contested hearing. Counsel, in regards to bonds, historically, I show about 18 days before this case arose, he was put on probation for domestic violence under 4A. That was revoked. He also had back in 10, the B&E illegal entry that has been set aside. And it appears the person in the domestic violence case and this case are the same persons. Mr. Hartel, any comment regarding bond?
Yes, Your Honor. I have been given a copy of the recommendation from the probation department. I realize that's putting the cart before the horse, but just for the record, clearly didn't get that. So the court's aware, this defendant, as they saying my clients, I don't know if they'll be the one assigned to me or not. His grandmother is in the courtroom for moral support. If given the opportunity at a personal recognizance bond, which we realize the court may or may not revoke him to the jail remand. That's the process. May or may not remand him to the jail pending the rest of these hearings. But if he's given the opportunity, he would gladly be able to go with his grandmother. I don't want to say she'll babysit him, but she'll definitely make sure that he's safe and cared for pending this hearing. If the court's concerned that he'll go to a location that he's not supposed to go, I'd ask the court to consider GPS tether with a house arrest, perhaps even. I realize that costs some money. That's unfortunate. But most house arrest conditions normally let him still go to work so he can afford to pay it. He is employed at MI Independent Living. He is a caregiver. To my knowledge, there's been no allegations of any issues with it.
Give the defense credit here. This is a smart, layered bond pitch. Instead of pretending the court has no reason to worry, counsel offers the judge alternatives: grandmother in the courtroom, family support, a safe place to stay, GPS tether, even house arrest if that's what it takes. Add in employment, and the message is clear. Judge, if you're nervous, we can build a structure around him instead of keeping him locked up. That's good advocacy. But here's the problem, and it's a big one. When the allegation is that he violated a no-contact order involving the same person the order was designed to protect, supervision starts sounding less reassuring. Because the court isn't just asking whether he has somewhere to go. The court is asking whether the victim would actually be safer if he were released. And once that becomes the center of the conversation, family support and work history stop being the headline and start becoming background noise.
So even though the court may have concerns about this alleged victim in this file, I don't think there's any concerns for the public safety in general. I'd ask the court to consider that and ask the court to give him a PR bond, whatever conditions the court needed to feel safe with that. Even if a small monetary bond was required to make the court feel comfortable, I don't doubt his family would help him out. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. I have some serious concerns for the victim's safety in this case. Sounds like this has been an ongoing issue. Him violating the no contact order. There is security camera footage that clearly shows the defendant trying to get into the victim's residence.
This is the prosecution stepping in and stripping the issue down to its hardest edge: victim safety, ongoing issue, security camera footage, alleged attempt to enter the residence. That is a tight argument, but it's effective because it doesn't overcomplicate the point. The prosecutor is telling the court, this is not theoretical, this is not old history, this is happening now and it is serious. And that footage matters because it gives the court something more concrete than just a claim floating in the air. Even though the violation still has to be proven at a contested hearing, bond decisions do not wait for final resolution. Judges make interim decisions based on risk, not ultimate guilt. And if the court believes there is real, immediate concern for the protected person, that can outweigh almost every softer argument the defense has. This is one of those moments where you can feel the hearing leaning before the ruling even comes out.
Given that, pending a contested hearing, I would ask for a remand. Thank you.
Thank you. The court is going to remand the defendant to the custody of the Wexford County Jail until we have the hearing. I believe that's appropriate, given that this is alleged to be a violation of the no contact order. This victim is the same victim that was in the domestic case, and the probation department report that Mr. Hartel referenced states throughout probation it has been challenging to get Mr. Graves away from the victim in the case, as we have had several reports stating he's been trying to reach her by various means. And then it goes on to describe that they too saw the video. So I do find him as a.
And the ruling is remand, straight back to jail until the hearing. That is a heavy move, but the reason matters. The judge is not saying the case is already proven. The judge is saying the alleged danger is too serious to gamble on in the meantime. That's a key distinction. This is about temporary custody based on risk, history, and what the court has been told so far, not a final adjudication of the violation itself. What likely sealed it is the pattern. Same victim. Alleged no contact breach. Reports that it has been difficult to keep him away from her during probation, and the mention that others also saw the video. When courts think a protective order is being tested over and over again, they often stop experimenting with softer options. That is the court drawing a bright line. Whatever happens at the hearing, we are not rolling the dice on safety before then.
Threat. So I will remand to the custody of the jail. Anything else for the record, counsel?
No, thank you.
All right. That's it. All right, we are adjourned. 25-1248 GC. We're here for a continuation of a creditor's exam from January 8th. Is there any resolution to this matter at all?
No, we talked a little bit, but nothing solid.
All right. And so normally I would send you in a room to discuss, but it sounds like you've already been discussing and haven't been able to reach an agreement.
No, with the weather, Your Honor, we just didn't have monetary, like I couldn't give them anything monetary right away with the set in stone.
All right, so what I'm going to do, Mr. Collins, will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right. And we're here for a, like I said, a creditor's exam. A default judgment was entered back on September 30th in the amount of $23,572.68. Mr. Collins, did you fill out the yellow sheet? Can you bring that up to me, please?
Your Honor. And can I explain the monthly?
Yeah, we'll go through
Okay,
that.
perfect.
Yep. Okay, so Mr. Collins, it looks like you own a 21 Traverse and a 13 Nissan. Looks like the Traverse has it, if I'm understanding correctly, it's got a loan on it.
Yes, sir.
And the value you put down is 20,000. Is that the value without the loan or with?
That's the value without the loan.
All right, and how much is the loan?
It's 760 and I think I'm about 3,000 upside down on it. So when I bought it.
So that's the 760 a month in the
Yes.
vehicle category?
Yep.
All right. How much is still owing on it?
20, my guess is like 22, 23.
When did you purchase that?
21.
And the Nissan, is that paid off?
It is paid off and, but it is no longer in my possession.
Do you still own it?
Yeah, it's in my name still. That's why I wrote it down, Your Honor.
Okay.
To be transparent, Your Honor, Steve and his business partner Dave actually has the vehicle.
Is that true, Mr. LeGros?
Yes, sir.
And what's the reason, Mr. LeGros, why you had the vehicle?
My friend David is a mutual friend of ours. Did some work for Jim and he gave my friend David the car for the work he did for him. And I had graffiti spray painted all over it. The back window was broke out, blah, blah, blah. We got several hours of scrub and spray paint off it, fixed the transmission, got it running. And my friend David tried getting a title for it for 2 months from Jim, and when he got it, it had a lien on it. So
So,
we're like several $1,000s in the hole on the car. You can't do nothing with it.
but that has nothing to do with this case, correct?
No.
All right.
In your honors.
Yes.
I guess, I'll just speak. It wasn't for work rendered. I paid him for work rendered. He needed a vehicle for him and his wife. And I provided a vehicle. It was just a friendship. Here you go, but if you gotta fix it.
He told me.
Now we jump into a creditor's exam. And if you think civil court is automatically less intense, think again. A default judgment for more than $23,000 is already on the books. So this hearing is about one thing: what can actually be paid? And what is the truth of this person's financial situation? That means the judge starts going line by line through assets, vehicles, bank balances, loans, expenses, and income claims. This is where people discover very quickly that vague math and kind of sort of answers do not land well in court. And here's why these hearings get spicy. They are about money, yes, but they are really about credibility disguised as math. The second your numbers get fuzzy, your story gets fuzzy. The second your assets seem to drift in and out of your control depending on the question, the judge notices. This may not sound as dramatic as a bond hearing, but trust me, once someone's finances are under the microscope, the pressure gets very real.
Okay, either way,
Yes, sir.
it's not being held as part of this case, so. All right, and then so it looks like.
Not to interrupt you again, Your Honor, my monthly can go up with miles driven, because it's a new position with iFly Trucking. That is based off of lower miles right now because of the inclement weather conditions and all that. Within several months, I'm hoping that I can put more miles down, which means more money.
It looks like you've got between two accounts, $551.10 in checking. When were those balances from? Or at least from, it looks like bank accounts.
It should be 896 and 155.
Oh, that's an 8. I'm
Yeah,
sorry.
sorry
I
about
thought
that,
that
Your
was a
Honor.
3. All right. So that's 1,051.10. And when were those balances from?
Those are new balances. The one,
As of-
the 8 something was from few days ago. And then the 155, I actually forgot about that. That is actually today's balance when I called them.
When you say a few days ago, is that within like 2 days, a week?
2 days roughly. That's what should be in there after my credit card payment came out.
And the monthly income of 3120 plus or minus, that's where you were talking about. It depends on the
Yes, Your Honor.
miles driven. When did you start that position?
It was this year, the beginning of the year with iFly. I was actually trying to start that position earlier, but I had to wait for a drug test to come back and my renewal on my CDL.
So when you say this year, 26?
Yes, Your Honor.
So have you received a
I
paycheck?
have
from
not
them?
received a paycheck yet. They closed down all the yards the last 2 weeks because of inclement weather, because it's we haul campers and Amazon vehicles. So they're a higher structure and the wind blows them over.
And so So let me ask you, have you driven yet for them?
No,
All right. And so this 3120 that you put down as gross income earned, how are you basing that then?
that's based off of mileage, my minimum mileage requirement to keep the job.
So you have a minimum requirement?
Yes, that'd be my minimum requirement.
And are you paid strictly on mileage or do you get an hourly with that as well?
Strictly mileage.
So loading and unloading, you don't get paid for that.
And I only get paid loaded miles. So on my way back, if there is no load, then basically they pay fuel and I basically drive.
So are you an actual employee of iFly or are you contracted with
I'm
them?
gonna be a 1099 employee until he switches it over to a W-2.
This vehicle section is a perfect example of how a straightforward financial hearing can suddenly turn into a maze. The Nissan is paid off, but apparently it's still in his name while someone else has it. And now we've got a whole side narrative involving a mutual friend, repair work, damage, title issues, and money allegedly sunk into the car. And the judge does what experienced judges do. He lets enough of it come out to understand the issue, then basically says, fine, but let's not lose the plot. Still, even if the judge is not deciding that car dispute right here, it absolutely affects the vibe of the hearing, because when an asset is technically yours but functionally somewhere else, that raises a giant credibility flag. Is this an honest mess? Maybe. Is it the kind of explanation that makes a court want more detail and less storytelling? Definitely. And that's the thing about these hearings. Side stories do not stay on the side for long when they start touching ownership and value.
And how long will you be a contract?
I'm hoping less than 3 months.
There's no agreement though?
Excuse me, Your Honor?
There's no agreement though?
No, it's usually 90 days.
Are you running their truck then?
Yes,
And is it a pickup? Is it a tractor?
it's a tractor.
And where are you running to and from?
Usually out of Goshen.
Okay.
There's a contract in Cadillac that I believe he picked up. It's hauling to Air Force bases through like big bomb containers, I believe they are. But he's working on that right now. So I would be leaving out of Cadillac, going to like Shreveport, Louisiana, or Kentucky or North Carolina.
So what is your minimum mileage?
The minimum mileage comes out to, I believe, $750 a week. No,
Okay,
excuse me,
but how-
it's $1550 a week.
How many miles are you required to drive?
$1550 a week.
Oh, 1550 a
Yep.
week, miles. Okay. How much do you get paid a mile?
It's about 55 to 65 cents a mile.
Okay.
That depends on the freight.
Sure.
And Your Honor, DOT, that's why I said I can make more. That's the minimum. If I run my ELD to, the allotted time and take your resets, I should be able to do about 3,000 miles a week, but that all depends on freight, timing, and weather.
Sure.
Here comes the big financial pressure point, projected income versus proven income. The defendant is giving the court a trucking income picture based on mileage, minimum weekly requirements, loaded miles, weather delays, and what he expects to earn once things get rolling. The problem? The judge keeps coming back to the same brutal question. Where is the actual paycheck? Because until money has really come in, a projection is just a forecast, and courts do not love building payment orders on forecasts. That's why the questioning gets so specific. Employee or contractor? year? How long in the job? Have you actually driven yet? How are you calculating that number? What's the pay per mile? What happens on unloaded trips? Those aren't random questions. The judge is pressure testing the foundation of the income claim. If the base number is shaky, the rest of the budget falls apart too. This is classic courtroom math. No matter how polished the estimate sounds, the court wants proof, not promise.
Well, then you've put down 800 for mortgage and rent. Is that mortgage or is that a rent?
It's rental.
You didn't put anything down for utilities.
No, because the sharing party pays the utilities. I pay a little more than on the rental payment part, and the other party pays the electric. I do help with the propane when necessary.
And 760 for the vehicle. Other loans of 603, what's that?
One Main Financial, just a personal loan.
Medical bills of 1250 total, is that a recurring expense?
No, it's just, that's not a monthly payment. That's for my son. That was the last bill I seen, was 1250 that I owed. And the insurance should have covered it, but they didn't, so I gotta figure out how to make payment arrangements on that.
So you didn't put anything down for insurance. Do you have a monthly insurance bill?
Yes, sir,
How much is that?
125.
125?
And some change, but it's usually 125.
The groceries of 500. Do you have any other expenses like child supports or alimony?
No child support, no alimony. I do have cell phone in my name, but the company's supposed to pay for it, so that's why I didn't put it down.
Okay.
That's supposed to be the added bonus.
And so let me just double check some math here. So taking out the 1250 out of your monthly bills but adding the 125 in, I come up with 2788. That sound about right?
That's gross, sir.
Which leaves a balance, subtracting that out from the estimated monthly income of $332. What about Unique Sign Company? Does anything come from that?
That is no longer.
And what about the building on Boone Road?
I basically have the lease till the end of March with the owner. I'm good buddies with him, and I just help him out right now. Like with cleaning and stuff, but I'm not operating Unique Sign Company out of there no more.
So that building's under lease?
Yes.
Your Honor, if I may ask a question.
Mhm.
Could you tell me what the address is he shows for McBain?
West Watergate?
People get that confused with M55, but it's if you put M55, it goes to the Cadillac post office. You put West Watergate, it goes to McBain.
Your Honor, if I may speak.
Mhm.
The last time we were in here on January 8th, he supposedly, his yellow paper was waterlogged, he couldn't read it, that's why he didn't fill it out. And in the same breath said that he had a McBain address. Apparently that's why he didn't receive the one in the mail. And then he got a new phone, that's why he couldn't get hold of me to work out a deal. I got home that night and the same phone number he gave me, I already had in my phone. We have Texas going back to March 2025. All my dealings with him over a year has been lies. I mean, I was in a bad place when I picked my car up from being lied to and letting him take advantage of me. So I just asked the court to take what he says with a grain of salt. Because I think he lied underneath oath last time. And as far as assets, either he's unloaded a lot or he's not telling the truth. And with that being said, the higher the monthly payment you can make is the only way I'm gonna see any monies. Because we're talking over $20,000 in the cars. That would be safe. Thank you, Your Honor.
Your Honor, can I talk real quick?
Yes.
Okay, when I said the last time we were in court, I did not lie. I said I did not have record, and we could probably pull that up of his phone number still, because I got a new phone, not a new phone number. I have two separate numbers, or had. I had a new phone. I contacted his buddy to get the phone number, and when we left the courtroom, I gave him my phone number, and he called me to call me. I did not call him because I did not have his number.
And that's the same phone number I had for since March.
Okay.
When he gave me in the courtroom on the 8th. So why he didn't have mine, I don't know, unless he deleted it.
All right.
Sorry, Your Honor.
And now we're fully in credibility combat territory. The creditor basically tells the court, this man has been lying to me for a long time, and I do not think the court should take what he says at face value. That is a serious accusation, especially in a hearing that depends so heavily on financial disclosure. Then the defendant pushes back with the broken phone explanation, saying it was a new phone, not a new number, and tries to explain how the communication confusion happened. At that point, the hearing stops being just about numbers. It becomes about who sounds believable under pressure, and the judge does not need to call anyone a liar in that moment for the warning signs to matter. Once perjury gets mentioned later, you know the court heard the problem loud and clear, because financial disclosures are not casual. You do not get to freestyle when the document is under penalty of perjury. That reminder is courtroom code for be very careful, because if this story falls apart, the consequences can get bigger than a payment dispute.
Defendant must bring in copies of his tax returns. All right, I will get that put into an order and we'll make sure everybody gets a copy of that. All right, thank you.
Your Honor, is there any way with the taxes?
Yeah.
That I told him this morning too, where whatever I get back, I sign off to him. Is that part, like, is that something I can do, or just, is that on good faith?
That I don't know. I don't know if there's a mechanism to do that, other than, I suppose. Yeah, I don't know. So I would talk to an accountant about that. All right.
Your Honor, should I still fill the papers out for garnishing wages and
I can't tell you what to do. That's entirely up to
all
you.
I have is personal information?
Yes, and we'll make sure. Yeah, he'll get a copy of that as well, of that yellow sheet. So,
Thank you.
all right. Okay, thank you. And we are here on a second, our second hearing in this matter. We adjourned last time for financial assistance. I've received proof of application. Like application. I don't see it when it was, oh, it looks like the 6th it was applied for. Have you received a response back? on
They
that?
did deny it, but I did just talk to my sister. She said she would pay it if I pay her back. But I tried to go to the office today and there's nobody there yet.
Okay,
She wanted to know how she could pay it or whatever. But she did say she would do it for sure. or December and January.
December and January.
Yes.
Counsel, do you have a balance owed on that? So she knows what is owed?
Yes, I have rent of $1,839.51. There are court costs of $207.60. So there's a total $2,047.11 due through January.
Through January.
Correct.
So I guess my question then is, do we want to adjourn or do we want to enter a judgment?
Your Honor, I would be asking for a judgment to enter today that would give until February 3rd for the balance, or February 2nd is 10 days for the balance to be paid. And that would give her enough time to coordinate with the management when they're in the office.
All right, so Ms. Norton, let me ask you, because they do have a right for a judgment to enter today. Do you agree that you owe $1,839.51 in rent and $207.60 in costs?
Yes.
You agree with that? All right, then the court will go ahead and enter a consent judgment at that point. Give me a moment while I fill it out. Okay, so I've entered an order that states by consent, which is by agreement, that the defendant agrees that they owe $1,839.51 in rent, court costs of $207.60. The court is giving till February 2nd to get that paid. The defendant will be liable for money damages after moving out if additional rent is owed or if there's damage to the property. If it's not paid by February 2nd, they can apply for a writ of eviction and have you evicted from the property. Acceptance of a partial payment does not prevent the court from issuing a judgment of eviction, and a no money judgment enters at this time. Now, because you are unrepresented, you have 3 business days to decide whether or not you want to follow through with this agreement. If you decide that you don't want to, you need to notify the court. All right, otherwise it'll go into effect after that 3rd business day. Man, if you can approach, you'll take it over to him. All right. And counsel, do I have your permission to sign on your behalf?
Yes, Judge, thank you.
All right.
The judge lands this in a very controlled place. $150 a month starting February 15th, with the whole matter coming back for review in May. That tells you the court is not fully convinced by the rosiest income picture, but it also is not willing to pretend there is enough certainty yet to hammer out a much bigger number. In other words, the judge is threading the needle. Enough accountability to move the case forward, but not so much guesswork that the order becomes detached from reality. And honestly, that's often what a careful judge judge looks like. The creditor wants more. The defendant wants breathing room. The income story is still developing. So the court creates a temporary structure and demands more documentation later, especially tax returns. That is the legal version of, I'm making a call, but I'm not done checking your homework. It's not flashy, but it's smart, and it keeps both sides on notice.
What's your P number?
85046.
Okay, I have signed that and we'll make sure everybody gets a copy of it.
Thank you, Judge. Have a great day.
All right, thank you, you too. Ma'am, you can go out to the front window and get a copy of that. Yep.
Okay,
All
thank
right,
you, Anna.
Thank you. And that completes the morning.
Now we're in landlord-tenant court, and this is where real life hits hard and fast. Financial assistance was applied for, but it got denied. The tenant says her sister is willing to help. The landlord side puts the balance on the record, and suddenly the hearing boils down to a brutally practical question. Do we delay again and hope the money materializes? Or do we enter judgment today and set a deadline with teeth? That's why this consent judgment matters so much. By agreeing to the amount owed, the tenant avoids a fight over the balance and gains a short window to fix the problem. But there's a catch. Once that order is entered, the path to eviction becomes much more defined if the money does not come through in time. So this is not a casual agreement. This is the court putting the timeline in writing. From here on out, the pressure is no longer emotional. It is procedural.
Just to answer his question, it's because I broke my phone, and when I got a new phone, all the numbers did not transfer over. And that's why I did not have his number at that time.
If there's any way I can list the beneficiary. I have a couple of health conditions and it's probably gonna take years to resolve.
I can't, there's not a process for me to do that right now. Just a moment here.
In your honor, I will get taxes back this year, and I could sign a tax form to him so it doesn't get drug out also.
What I'm going to do. Mr. Collins, I'm not saying one thing or the other, but I just want to make sure that you understand that the information you provided here that was under penalty of perjury, you do understand that, correct?
Yes, sir.
Because we are starting with a new job, we really don't know what income is, and tax returns are not done yet. What I'm going to do is enter a installment payment order of $150 a month. That's half of the disposable income that I calculate, starting February 15th. And the 15th of each month thereafter. We will put this back under review at sometime in May. And we will revisit the assets, tax returns, and that sort of thing. All right. Mr. LeGros, I would like to give you more. It's just based on what I've been presented with today. I don't have the ability to do that. But what I am going to require is at that May review.
What makes this courtroom session so compelling is how different the cases are, but how similar the lesson is. In the first case, the court gave a defendant on a drug charge a chance to stay free under strict conditions. In the second, the court decided the alleged risk tied to a no-contact violation was too serious and ordered jail pending hearing. In the creditor's exam, the judge sorted through shaky projections, disputed assets, and credibility concerns before setting a temporary payment order and demanding more proof. And in the housing case, the court entered a consent judgment that gave a narrow chance to pay before eviction remedies could move forward. Different facts, different law, same pressure point every single time. When the judge starts asking hard questions, does your story hold up? That is what this whole docket came down to. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.